SRA 211, Session 3.4.2, Legal Aspects of Counterterrorism Policies, Part 2. We will finish up our discussion of legal aspects of counterterrorism policies by looking now at the interplay of counterterrorism operations and civil liberties, and in particular we'll examine a few laws that are pertinent to that. The first one is something called the USA Freedom Act of 2015. The second one, that is probably more familiar to you, is the USA Patriot Act, which was passed in the immediate aftermath of the 9/11 terrorist attacks. And the final law is something called the Foreign Intelligence Surveillance Act, or FISA, of 1978. The aftermath of the 9/11 terrorist attacks saw the adoption or the amendment of legislation that was designed to beef up the United States counterterrorism capabilities. The new law or laws were the USA Patriot Act, which, as stated, was passed in the immediate aftermath of those attacks, and then subsequently some other legislation, including the USA Freedom Act of 2015. The law that was amended was a pre-existing law, the Foreign Intelligence Surveillance Act. Some provisions of these laws have been criticized by civil liberties groups as potential threats to the rule of law and to civil liberties in the United States. In this country, the criticism has in fact focused on certain elements of both the Foreign Intelligence Surveillance Act and the USA Patriot Act. Before we get to these two older laws, let's take a quick look at the most recent piece of legislation, the USA Freedom Act that was passed in mid-2015. This law does a number of things. One part of it deals with the bulk collection and surveillance programs that were allegedly run by the United States government. It also has relevance in that it amends several provisions of both the Foreign Intelligence Surveillance Act and the USA Patriot Act. In fact, it extends the applicability of the provisions of some of those laws. So the one thing that the USA Freedom Act did was limiting the bulk data collection of Americans' phone records and internet metadata, again in response to revelations about government programs that were collecting and analyzing such metadata. We don't need to say too much about this law here, other than to note that this law does limit the government's data collection, in the words of the legislation, to the greatest extent reasonably practical. For example, the government can't collect all the data pertaining to any given service provider or big chunks of the country, such as cities or metropolitan areas, or all of the metadata from a certain area code, things like that. That's now prohibited. Instead of this bulk data collection, this law authorizes the government to collect information, metadata, really related to a suspect, assuming that the government has reasonable suspicion that a certain suspect is linked to a terrorist organization. Once that finding is made, this law allows the government to collect what they call 2 hops of calls related to a suspect. That's sort of doesn't sound technical, but it's kind of a technical term that means once you have a suspect identified, the government then can collect metadata about calls made and received by that suspect, and then by all of the individuals who talked to the callers who were calling and talking to the individual. So it extends to the callers and people with whom the suspect speaks, and then all of the people who speak to them. That's the concept of 2 hops. That's still less than some of the more extensive collection that had been done under prior government programs. So that's the one basic feature of this law. The other main thing the USA Freedom Act does is to amend to a certain extent the other 2 laws, the USA Patriot Act and the Foreign Intelligence Surveillance Act, as well as to formally extend certain of the existing provisions in those laws that otherwise would have been subject to something called a sunset clause. meaning that these parts of the law go away after a certain number of years unless they are reauthorized by Congress. So let's take a closer look now at these other two laws, the USA Patriot Act and the Foreign Intelligence Surveillance Act. We'll start with the USA Patriot Act, which, by the way, USA Patriot is a very long acronym, which I won't say here. Look it up if you want to know what it means, but it means something. Basically, this is the law that was passed in the sort of immediate aftermath of the September 11th, 2001 terrorist attacks. It did, in fact, enact a number of changes to various other laws that were aimed at combating terrorism. For the most part, the USA Patriot Act expanded law enforcement access to various types of communications, as well as certain types of medical and financial records and other data. Provided for some easing or additional easing of restrictions on foreign intelligence collection in the United States. The law also expanded the Treasury Department's regulation of certain financial transactions involving foreigners. And finally, it gave authorities greater discretion in detaining and deporting immigrants who are suspected of terrorist acts. Now, these are, so far, are the broad thrusts of the Patriot Act, sort of the broad outline of it, and the main areas. There are also a number of specific provisions in this law, some of which have given rise to concerns about their possible effect on civil liberties. One of these is a new and by some considered a broad definition of domestic terrorism. The key elements of this definition are criminal acts dangerous to human life that aim to intimidate or coerce a government or civilian population. Now, of course, what's logically intended here are things like the use of weapons of mass destruction, assassinations, explosions, bombings, kidnappings, and so on. But technically, and this is the concern of some in the civil liberties community, the concern is that this definition is overly broad, that in its literal sense or its legal sense, a criminal act dangerous to human life that aims to intimidate or coerce, that could encompass certain types of civil disobedience or protests that historically have enjoyed protection in this country, or other sort of minor criminal offenses. One example that has been cited was protests against the transport of nuclear waste material from a nuclear reactor actually in Germany, not in this country. But there were opponents of the plans to bury this nuclear waste, and to voice their concerns, they tried to block the railroad tracks where this train carrying the nuclear waste was traveling. They chained themselves to the tracks. That certainly was a criminal act. They were warned not to do that. Certainly was dangerous to human life. And it did aim to coerce or influence the German government. So I guess the concern about some people in the civil liberties world is that this definition could include that type of thing that really is more in the line of civil disobedience or legitimate protest. In any case, that's one of the provisions that has generated some concern. Another provision that has generated some concern is something in the Patriot Act that is sort of in slang referred to as the sneak and peek warrant. What does that mean? Now, probably you've heard in your careers of the concept of a search warrant. Now, this is not a law course, so we won't get that down into the weeds about the legal aspects of this in that sense, but the Fourth Amendment to the U.S. Constitution, which governs the issuance of search warrants, generally requires notice to the person whose premises are being searched prior to the execution of the search warrant. Of course, as you've probably seen in the police shows, the notice can be 10 seconds as the police are battering down your door, but you have the right to see the warrant that is being presented to you and to be present during the search. The Patriot Act, in certain cases, certain exigent cases, or what are called emergency cases, allow a delayed notice of the search warrant. These are the so-called sneak and peek warrants. So the government may delay a notice to you. In other words, the government may come in and search your premises while you're not there and only tell you after. if a court in advance concludes that there is, and this is the test, reasonable cause to believe the notice will create an adverse result. What is an adverse result? Things that have been cited as examples are physical danger to the officers, destruction of the evidence, possible flight from prosecution. But these are all the same things that apply in a regular criminal case where there are Fourth Amendment advance notice protections. So the main concern about this on the part of the civil liberties crowd is that these covert searches, where you're not even told in advance that your premises are going to be searched, and it's done while you're not there, they don't allow the suspects to safeguard their rights during the search. I'm not sure how much you have a chance to safeguard your rights anyway, but this is the concern. Another provision of the USA Patriot Act that has generated some controversy is something called the roving wiretap provision, or the so-called John Doe wiretap. Now, in a normal criminal case, to get a wiretap, a police officer or a judge or a district attorney needs to get a court order that would specify a person or persons whose devices are going to be monitored, and then also provide some information about the devices themselves. That's in a normal criminal case. In the context of the Patriot Act, which of course applies now to counterterrorism, there are some less stringent provisions. In fact, the roving wiretap provision allows officials to conduct surveillance on terrorist suspects regardless of how many communication devices they use, cell phones, internet, satellite phones. This is, of course, a response to the fact that terrorists have become very ingenious in using, quickly changing their modes of communication, using disposable prepaid phones, satellite telephones, things like that. Now, approval for the surveillance must be obtained from something called the FISA Court, the Foreign Intelligence Surveillance Act Court, which was set up pursuant to the other law we're going to look at in a minute. The controversy is that such a wiretap may be obtained without identifying the target really, specifically, or what method or methods of communication are to be accessed. So this has generated some concerns among civil liberties lawyers and others. This law specifically had been subject to a sunset clause, and it has been re-extended by the USA Patriot Act to 2019. The final provision of the USA Patriot Act that has generated a lot of debate is the famous or infamous Section 215. This is the one that, again, only when the Patriot Act is applying, not in a regular criminal case, but in a counterterrorism related investigation. It provides for the production of tangible things, books, records, papers, documents, for these foreign intelligence and international terrorism investigations. This access includes access to business records in cases involving terrorism, foreign intelligence, or surveillance with judicial approval. Now, normally you have to get judicial approval anyway to search these types of things in a criminal case. But Section 215 gives the government the power to obtain certain business records without a showing of what's called probable cause. Now, again, this is beyond the scope of this course, but basically under the Fourth Amendment, in order to get a search warrant for a general type criminal case, you need to show probable cause that a crime has been committed or that evidence will be found of a crime or relevant evidence in the place to be searched. You don't necessarily need to meet this threshold in applying Section 215 in a Patriot Act case, and this again has generated some controversy. This provision was likewise subject to a sunset clause and has been likewise extended till 2019. We will conclude now with a quick look at the final bit of legislation that has relevance to counterterrorism and also has generated some controversy, and that's the Foreign Intelligence Surveillance Act of 1978, often referred to as simply FISA. FISA prescribes procedures, and again, it did this since 1978, before the Patriot Act, for requesting judicial authorization for various types of electronic surveillance and physical searches of individuals believed to be engaged in espionage or international terrorism against the United States on behalf of a foreign power. Now, foreign power it's been clarified that that includes groups engaged in international terrorism. So Al-Qaeda or ISIS, even though they're not a recognized government, they qualify as a foreign power. Now, these judicial requests are considered, adjudicated, by a special 11-member federal court called the Foreign Intelligence Surveillance Court. And this law permits, in certain circumstances, electronic surveillance without any type of warrant, which makes some people uncomfortable. One of the main concerns expressed about FISA on the part of the civil liberties organizations is the so-called lone wolf provision. In 2004, FISA was amended by Congress to authorize intelligence gathering on non-United States persons, so not Americans, who engage in international terrorism or activities in preparation for international terrorism, but who are not affiliated with any known terrorist organization. Remember that originally under FISA, you had to be a subject of this FISA law, you had to be investigated, and the allegation or certification must be made that you were a foreign power or an agent of a foreign power. This had, of course, been amended to include or clarified to include terrorist organizations. But what do you do about the lone wolf people who are maybe inspired by a terrorist organization but are not actually a member of that organization? So this lone wolf measure provides that such an individual who's not affiliated with any known organization but is still planning terrorism is deemed to be an agent of a foreign power. I guess you're sort of an agent of yourself. You're an individual foreign power. The government's not required to demonstrate any connection between the target of the electronic surveillance, the person, or the physical search, and any foreign nation, foreign group, or international terrorist group. In other words, if you're a terrorist and you're not an American, you can be subject to surveillance under FISA because you'll be considered to be your own foreign power. And this, of course, has some people scratching their heads about what the whole purpose of that foreign power requirement was then. This provision was going to go away as well, but has been extended, as have some others, as you've seen, by the USA Freedom Act. And with that, we'll conclude our look for now of sort of the legal aspects of counterterrorism policy.